Good afternoon, everyone, and welcome to the AFME member briefing call on GDPR compliance in financial services. This has proved to be a very popular topic. We've had more than 200 members register to join us for this call. And for colleagues that couldn't make it, there will be a recording on the AFME website in the next couple of days. I'm Richard Middleton, and together with Will Dennis, I lead AFME's policy division. The division works on a number of important regulatory issues, including data, financial crime, and conduct and culture. We've identified data as a key theme, and our work programme includes GDPR, e-privacy regulation, international initiatives on information sharing, and the interaction of GDPR with other regulation. We also coordinate our work with AFME's technology and operations team, which covers topics in cybersecurity and fintech. The current most pressing issue for members is the GDPR, and AFME's data working group has engaged with the European Commission and with the Article 29 Working Party to help shape the legislation and the guidelines. And while the guidelines are still not fully finalised, the implementation date of 25th of May is fast approaching. We are therefore very pleased to host the briefing today on GDPR compliance. I would like to briefly introduce our panellists. Nicola Kershaw is Head of IP Technology and Procurement, DIB Legal at BNP Paribas. Nathan Coffey is EMEA Head of Data Privacy and Technology Compliance at JPMorgan. Nicola and Nathan are also co-chairs of the AFME Data Working Group, together with Claire Royal from Bank of New York Mellon. And Richard Jones, Director of Data Privacy at Clifford Chance. Richard has advised the Data Working Group on a number of issues, including transfer of data to third country courts and regulators, and also on the scope of the e-privacy regulation. The running order today is that Richard will give a presentation on the GDPR and on steps that firms are taking to ensure compliance, and there will then be an opportunity for Q&A. You can submit questions for the Q&A at any point during this briefing by clicking on the Q&A icon on the right-hand side of your screen and typing in your question. I would now like to ask Richard to take us through his presentation.
Thank you very much, Richard, and good afternoon, everybody. Sorry, a slight technical problem that we'll solve in a moment. So I'm going to essentially give you an introduction to the key concepts of the GDPR and the broad compliance steps that firms are already well engaged in taking in order to comply. I'm not going to dwell on the situation under the current EU data protection regime, but I am going to try to stress where we're moving into new territory as opposed to repeating old themes. So to begin with, just as by way of starting point, the key features of the existing regime. So these are things that are common to data protection law across Europe as it stands now and to the GDPR. So to some extent, the GDPR is business as usual. And I want to set this out so that I can provide a context for the things that really are new. So the regime regulates processing, in quotes, of personal data being defined very broadly to cover any information, essentially, with some limitations, but essentially any information relating to an identified or an identifiable individual. And processing is also very broadly defined, so essentially anything you do, including mere storage or deletion of personal data, is caught by the regime and therefore regulated. So the approach taken by the regime is to throw a very broad net over a very wide range of activities and then apply some rules. At the moment, a relatively narrow set of rules, and as we'll see under the GDPR, it goes substantially wider. So, but these core requirements, that there's this concept of justification or legitimacy. All processing of personal data has to be justified by meeting one of a series of specified conditions, which is set out in the law and will be in the GDPR. So, for example, and we'll explore this in a little more detail later, one of the available conditions is consent. So if the individuals concerned have agreed that you can process their data, sounds simple, but unfortunately it isn't, you can go ahead and do it. In the absence of consent, and if you don't meet one of the other conditions, such as necessity, needing to carry out the processing in order to perform a legal obligation, your processing will be prohibited. So that's the starting point. Then around the concept of legitimacy, there are a series of what in the UK are known as data protection principles. And these are requirements which at first sight sound like motherhood and apple pie, but the more you think about them in particular business contexts, the more difficulties you run into. So essentially, everything has to be fair, proportionate in the sense that you shouldn't be collecting and using more data than you really need, given whatever it is that you're doing. Time limited, so you should delete data when you no longer need them. Secure, and there are one or two other of these core basic data protection principles. The next sort of category of requirements is transparency. Individuals need to be informed, according to the regime, about the processing that is being carried out of their data. And this is essentially so that they can keep an eye on what's going on, they can find out, they can then use that information to take steps to protect their privacy or to express concerns. And that, again, it sounds straightforward and sensible, but in practice, in many business situations, providing information is difficult, it may be undesirable, and you need to closely examine exceptions and the full scope of the information that needs to be provided. Then alongside that, having been informed of the processing that you're carrying out, individuals have rights which they can exercise against controllers, that is, firms in this context. And on the slide, I've mentioned access, correction, and objection rights. In the current regime, the main focus of data subject rights is on subject access. So individuals will demand access to personal data that's held about them, principally in practice, so that in the hope that they will be able to find amongst that information things that they can use against a firm, either because they're a disgruntled former employee or because they think there's a possibility of bringing a mis-selling claim or some other claim against a controller. So these rights are not usually exercised for data privacy purposes, but the reason they exist, again, is intended to allow individuals to take steps to ensure that their privacy is protected. And then finally, in this brief whistle-stop tour, there are restrictions on the transfer of personal data outside the European Economic Area. And the point of that is just, obviously, the rest of the world does not consistently have the same data protection standards as we do in the EU or the EEA. And there's a concern that data may be moved outside in order to escape the tentacles of the regime. And therefore, there are restrictions designed to ensure that in practice, the data continue to be protected, even when they're in the US or India or wherever they end up. So the key, I'm now going to talk about the key changes introduced by the GDPR. And the first one, and I put this first because it's relevant to the requirements of the current regime, which are going to come under a lot more sort of scrutiny and pressure than they have in the past. Even where the actual requirements haven't changed, is that there are new and very severe sanctions for breach. So the GDPR preserves and enhances various sanctions which are available under the current regime. So data protection authorities have powers of audit which vary across the EU to a considerable extent. They're almost non-existent in the UK under the current law. But they will be freely available under the GDPR. So data protection authorities will be able to come in and audit organizations. They can issue orders requiring changes to be made to correct breaches. Individuals can seek compensation through the courts if they suffer damage or distress as a result of breaches. But of course, an individual will not typically bring a claim seeking a very small amount of compensation for damage or distress that they have suffered, but the GDPR introduces the possibility of class actions being brought by groups of individuals, and therefore give some real teeth to that limb. But then perhaps, most eye-catchingly, the supervisory authorities will now be able to impose very substantial fines for non-compliance. And as you'll see on the slide, the maximum fines are set at very high numbers. So for the more serious kinds of breach, like processing data unfairly, essentially, the fines are capped at the higher of 20 million euros and 4% of the global annual turnover of the group of companies in which the controller that breached the GDPR sits. So for obviously for an international financial institution, that's potentially a very high amount of money. Remains to be seen how these fining powers will be used, but they certainly provide a very strong incentive to comply. So one thing that the GDPR does is it tightens existing rules. So I mentioned a couple of minutes ago that a key feature of the regime is this concept of justification or legitimacy. All processing needs to meet one of the conditions specified in the law. And I mentioned that one of those conditions is consent. Now, one thing that the GDPR does is essentially to codify attitudes that data protection authorities have increasingly been taking over recent years in any case to consent, and perhaps to push them even further than the view that the authorities have been taking hitherto. So essentially, consent is now a basis on which data can be processed only where the processing that you're engaging in is genuinely optional. So you're asking somebody for their consent. If they don't give it, you say, okay, fine, I won't process your data in that way. And of course, in most business circumstances, that is not a feasible approach. And just to explain that a little, there's a principle in the current law that consent to be effective has to be freely given. Now, the GDPR amplifies on that by saying it can be withdrawn at any time, and you have to point out when you obtain the consent that it can be withdrawn at any time, and indeed you have to facilitate withdrawal of the consent. The GDPR also spells out that consent won't be affected if there's an imbalance of power between the controller and the data subject. So, for example, in an employment context, it will almost never be possible to obtain an effective consent. And then consent needs to be informed, and you have to keep a record of the consent having been obtained. So we're really moving from a situation in which there's a very widespread reliance of consent. There's a kind of a tendency to collect consents as a sort of knee-jerk step, even if you're not entirely sure that it will be effective, to a world in which you really have to examine closely the legal basis on which you're entitled to process data, and it usually won't be consent. More commonly, firms will be relying on what's known as the legitimate interest condition. So they'll be taking the view that they have a legitimate interest in continuing to process data which is not overridden by prejudice to the interests of the individuals who are affected. Now, the difficulty with that, although it's quite generous in its sort of breadth, is that it does require you to have thought it through. You can't, at least in the scheme of the GDPR, you can't really go back later and say, oh, that processing must have been justified on the basis of legitimate interests. You'll need to be able to show that you had thought about it before you embarked on the processing and satisfied yourself that you had a legitimate interest, that the processing was necessary for it, and that interest overrode any associated prejudice to the rights of the individuals. So there's a shift in balance away from consent towards a more careful consideration of the respective rights of the controller and the data subject. So next, transparency. So structurally, the law is essentially the same in the GDPR as it is in the current EU data protection scheme. There are requirements to provide information to individuals whose personal data you process, both where you collect the data directly from them and where you collect data indirectly from third-party sources, which obviously gives rise to technical difficulties. The difference is that whereas the current law essentially says you have to tell them who you are, why you're collecting their data, and anything else they need to know to ensure that your processing is fair, the GDPR spells out a long list of very prescriptive and specific items of information that have to be provided. And the difficulty with that is that it moves you from a situation where, in many cases, you will take the view, essentially the individual I'm dealing with knows who I am. They know that I'm collecting their data in order to manage my firm's relationship with them, and there really isn't very much else I need to provide, to a world in which, in theory, you should be providing them with a privacy statement which sets out quite a range of detailed information about things like their data subject rights, whether the data may be transferred internationally, and if so, how the data are protected, how long the data will be kept. And so a lot of thought has to be given to how this information is going to be provided in common business situations where it isn't usual and nobody expects that data privacy notices will be handed over. So that's a new area of complexity. Then security. The basics of data security are essentially unchanged, I would say, in the GDPR. There's a general requirement, slightly more specific than in the current law, to have appropriate technical and organizational security measures in place to protect the personal data that you hold. The two aspects of the regime, though, that I would draw attention to, which are new, are firstly, there are now quite prescriptive security breach notification requirements. So if you become aware that data that you hold about individuals has accidentally been published on the internet, or you've been hacked, it's been a former employee has taken information away, you may very well be required under the GDPR to notify data protection authorities, and in some cases you'll also be obliged to inform the individuals concerned. So firms need to be prepared to respond. Well, I mean, they need to be prepared in any case to respond to security breaches in order to address and mitigate the consequences, but they will now specifically need to take into account these reporting and notification requirements. And then secondly, again, as in the current regime, where processing of data is outsourced to a service provider, so for example, an IT company, the regime requires that that relationship is documented in a contract which imposes some security and other obligations on the service provider. But whereas in the current regime, those obligations are relatively limited and can be addressed fairly briefly, although there's a whole world of thinking that has made that more complex than it perhaps needed to be. In any case, that's by the by, because under the GDPR, that there again is a long list of very specific, complex provisions that need to be included in these contracts. And there is the difficulty there that applies to contracts that are in place now, when immediately the GDPR takes effect on the 25th of May. So in principle, firms need to have been through all of those relationships, identified the contracts, negotiated with the service providers, amended them to address the requirements of the GDPR, and then they need to be geared up to ensure that similar provisions are included in their similar contracts going forwards. Just moving on to the next slide. Right, okay. Automated decision taking. I'm not going to go into this in detail, but there are new and very tight restrictions on the use of what the GDPR calls, or actually what we commonly call, automated decision-taking techniques. So these are techniques which are used to make decisions about individuals, essentially by computer or by other automated means, without human intervention. So it's where for example, in the case of credit checking, where a series of bits of information about an individual are fed into an algorithm which spits out the answer you can have credit or you can't. And there are a range of other circumstances in which these techniques are used. And the starting point of the GDPR is to outlaw these techniques, at least as the GDPR is most commonly understood, because it's not entirely explicit on this point, but subject to exceptions. So effectively, you can do it with consent, but I've mentioned all the problems that there are with reliance on consent, or in circumstances where you are authorized by law specifically to carry out to use the techniques, or use of the techniques is necessary for entering into or performing a contract. So very careful attention is going to have to be paid to circumstances where these techniques are used in order to determine whether they fit within any of these very narrow exceptions. And just one point to make is that use of these techniques to process data in the sensitive categories, but that is information about criminal record, health, sexual orientation, and so forth, it is effectively outlawed, except with the consent of the individual, which it sets a very difficult standard. So, so the use of these techniques is very narrowly circumscribed. Then moving on to data subject rights. Now, I mentioned that in the current regime, the emphasis has been on subject access because individuals use these rights to find information which they can rely on in claims against firms most commonly. That aspect of the regime is preserved. I would say the most significant other change in relation to rights is in the area of objection. Now, in the current regime, there is a right for individuals to object to the processing of their personal data. So someone can come to you and say, you're processing my personal data for a given purpose. I now want you to stop. And except in relation to direct marketing, where there's an absolute right to require you to cease, that's actually in practice has turned out to be rather a weak right, because the individual has to be able to show that they have compelling reasons which override your own interest in continuing the processing. So in practice, that right has very rarely been exercised. What the GDPR does is to swap the burden of proof. So instead of the individual having to come to you and say, I have compelling grounds for you to stop processing personal data about me, they come to you and object, and you then have to show, on the contrary, that you have compelling reasons for continuing the processing, which outweigh the concerns of the individual. So one can see, although it's yet to be seen because the GDPR is not in force, that the individuals will begin to seek to use this right, and firms are going to have to be very carefully prepared so that when they receive an objection, they're able swiftly to move to explain the basis on which they take the view, assuming they do take the view, that they have compelling reasons for continuing with the processing, so as to be able to continue and exploit and use the data as they need to. Right, and then, so far I've been talking about essentially aspects of the current regime which are being tightened up and made stricter than they are at present. On this slide, I'm going to talk about a set of essentially new requirements which come under the general heading of accountability, which is not a concept which is used in the GDPR itself, but it's commonly discussed in connection with it. And just to give 2 minutes of background, I think it's fair to say that there was a feeling amongst data protection authorities and the European Commission in relation to the current regime that although it had succeeded in some ways in improving data processing practices, it had not succeeded in making privacy part of the culture of organizations. To be fair, that's probably more true outside the financial services sector than within it, where there is at least a very strong compliance culture. But certainly across the board, the feeling was people are complying with the technical requirements of the Data Protection Act in the UK, for example. They're making registrations with the Information Commissioner's Office. They're drafting privacy notices. They're putting terms in their contracts, but they're not really taking privacy seriously. So in order to address that, the GDPR steps back from the concept of legitimacy and the data protection principles, which are all there still, as it were, on the surface, and it imposes a new set of requirements which go inside the organization and are quite prescriptive as to the things that you have to do in order to comply. So most generally of all, I suppose, there's a requirement buried somewhere in the middle of the GDPR requiring you to implement appropriate measures to ensure and indeed to be able to demonstrate that you have ensured compliance. So this goes back to a point I made a little earlier. It won't be sufficient to be able to say, if somebody challenges you, well, now that I think about it, that processing was justified because it was legitimate. You will have to be able to show that when you engaged in the processing, you had thought that through and you had determined that it was justified because it was legitimate and it didn't prejudice the rights of the individual. And that determination will have to be documented. In the absence of being able to show that audit trail, you're going to be in a very weak position if challenged. And that, again, goes back to the objection point. Similarly, but more specifically, there's a requirement to build data protection principles into the design and procurement of systems. So you'll need to, obviously, in principle, your systems need to allow you to comply with the rules in any case, but you need to be able to show that you have specifically thought about privacy in your procurement process, thought about the way that the system is set up, the data that it collects. Do we really need all of that data? Could we pseudonymize it, as the expression is in the GDPR, so that it's less likely to have implications for the privacy of the individuals? Is it sufficiently secure? So again, you need to be able to show that data protection is a part of the culture of, in this case, your technology and procurement function. Third accountability requirement is the concept of the data protection impact assessment. This only applies to high-risk processing arrangements. It's not a very clearly defined concept as yet, although there is some guidance on it. But in those contexts where processing poses high risks for the rights and freedoms of individuals, you're required to go through a process of considering the risks, how they will be addressed, documenting that, reaching a conclusion that the risks are satisfactorily addressed. And in an extreme case, if you conclude that you can't adequately address them, consulting a data protection authority. Although that's not something that I expect will be happening often in practice. But just to make the point on the slide, you need to conduct some sort of assessment in order to decide whether a data protection impact assessment is necessary. And even if an impact assessment is not necessary, you will need to have conducted some sort of assessment to assure yourself and to be able to demonstrate that you've assured yourself that you are complying with the rules. So in practice, there will need to be some level of impact assessment of all processing systems which process any personal data. So this will go very wide within organizations and require a very kind of conscious, thought-through approach to privacy compliance. Then just to pick up a couple of, I suppose, more, in a sense, more formal things, there's a requirement to have a data protection officer, which only arises, as the slide says, in some circumstances, but my experience is that financial services firms, by and large, are taking the view that they fit within those criteria and therefore need to appoint data protection officers. And there are requirements about the role and nature of the data protection officer. Essentially, they have to act in a way that is independent of the interests of the company, so that they can, as it were, act as an advocate for data privacy concepts within the company. And then there's a requirement to keep a record of processing of personal data and of the consents that you've obtained, which whilst the requirement is, we may come into this later, whilst the requirement is to keep a fairly high level record, in practice, pretty detailed records are going to be needed in order to be able to demonstrate that you're meeting the other accountability requirements that I've discussed on this slide. Extraterritorial effect. So this is a slightly different subject, but it's another change which is causing, in my experience, some consternation outside the EU, some of which is unjustified, but not all of it. In the current regime, the GDPR applies to processing of data which is carried out in the context of the activities of an establishment within the EU. So if you are a London-based or a Paris-based financial services institution and you're processing personal data, you will be regulated by the current data protection law, and that will be the same under the GDPR. One difference is that if the processing is outsourced to a service provider, known as a processor in both the current and the new regime, under the current regime, processors, with some exceptions in some countries, don't have any obligations of their own. They are merely regulated by the contract that the controller puts in place with them. Under the GDPR, processors will share liability for quite a lot of aspects of the regime, particularly in relation to security, but not only in relation to security. However, the GDPR also introduces a new concept which applies its requirements to organizations which are entirely outside the EU if they carry out processing activities which are related to either offering goods or services to data subjects in the EU or monitoring the behavior of data subjects in the EU. So in principle, you could be a US-based institution with no offices in Europe, or at least not in the EU, but you could be caught by the GDPR on either on the basis that you're offering goods or services or on the basis that you're monitoring behavior. Now, exactly how these criteria will be taken to apply is not yet entirely clear. In relation to offering goods or services, it is clear that there needs to be an element of targeting, so the mere fact that individuals within the EU may receive your offers and respond to them doesn't in itself make you subject to the GDPR. But if you were deliberately trying to solicit business for people in France or the EU generally or Italy, you likely would fall within the scope. There isn't an equivalent concept, at least not explicitly, in relation to the monitoring of behavior. So in principle, organizations in Japan which download cookies onto the devices of individuals in the EU and process related data about them may be caught by the GDPR, and that is an odd conclusion from a policy perspective. One point to make, though, is in one respect, the GDPR is less extensive in its scope than the current regime. Under the current regime, essentially, any processing which takes place physically within the European Union will be caught, even if it is controlled from the US or Japan or wherever. That concept is jettisoned by the GDPR. So in principle, a foreign organization could outsource processing to Ireland or the UK or Latvia, and that processing, at least from the point of view of the foreign organization, would fall outside the scope of the regime. The processor in Ireland, the UK or Latvia that was carrying out the processing would be carrying out that processing in the context of its local establishment, and therefore would be subject to the rules that apply to it as a processor. But from a kind of purposive control perspective, the GDPR would not apply, and that is, it's a small change, but it's welcome in terms of encouraging non-EU controllers to use European processors. Just to mention that the GDPR is a regulation of the European Union, and therefore it takes direct effect in all the EU member states. So that will create a much greater degree of harmonization than the current regime, which it takes the form of a directive implemented by laws in each member state, which vary quite a bit as to their effect. However, it does effectively require local laws to be made to fill in various gaps and make exceptions. And I've identified on this slide 3 key areas where there are likely to be significant differences from one country to another. One is in relation to HR processing, where the GDPR allows member states to impose additional rules, essentially, a fairly blank check for stronger regulation in particular countries. One is in relation to data protection officers, where the GDPR only requires appointment in quite narrow circumstances, but it allows the member states to broaden those circumstances if they see fit. And finally, in relation to sensitive personal data, which I mentioned earlier, so health, criminal record, and so forth, although there are some provisions in the GDPR, at least not so much in relation to crime data, but in the other categories, essentially the member states are left to take a policy decision as to the circumstances in which processing of that kind will and won't be permitted. Now, I'm going to talk briefly about some key compliance steps that firms are taking, and then I'm going to move on to give an opportunity for discussion. So the first thing is, and this in practice, of course, given that we're now at the very end of February and the GDPR takes effect towards the end of May, much of this should already have happened. Firstly, firms need to consider when and where the GDPR applies to their business. So that requires quite a detailed audit of the processing that's carried out in the business and a gap analysis between the requirements of the GDPR and the compliance steps that are already being taken. And that's going to involve identifying the particularly high-risk areas where it's most important to take steps to ensure compliance. And as part of that process, preparing a record of processing as required by the GDPR, and thinking about the future. So this isn't a one-off exercise. It's necessary to be prepared to refresh your records as time goes by and your business changes. Secondly, what I've called justification strategy. So as I've said on this call, in looking at all the processing operations within a firm, it's necessary to think and also to review previous decisions as to how you are justifying your processing of personal data. And there may be many circumstances in which there has in the past been reliance on consent, and that has to change. You have to think about how you manage the process of moving from consent to another basis for justifying processing, and you need to document the results. Under the general heading of accountability, I've included here review of security and IT readiness, including breach readiness. So a particular very knotty problem is how well are our systems set up to ensure that we can, for example, delete personal data when we no longer need them. That gives rise to a whole lot of complex considerations. Find data if we need to in response to a subject access request or an objection, and then respond appropriately. And in practice, moving into a world in which every firm has perfect systems which can respond immediately and beautifully to any outside interaction and which can deliver complete compliance, it is not going to happen. But firms need to be, and are, in my experience, focusing on the areas where they're holding a lot of more sensitive data, which gives rise to serious risks, and they need to move to compliance as swiftly as they can. Transparency, so this is a more, I suppose I might say, a more superficial exercise. The need to look at the channels through which information is being provided to data subjects, update privacy notices to provide all the information that's required by the GDPR, think about all the difficult issues to do with how exactly do I explain in a privacy notice how long I'm going to keep personal data about what may be quite a wide range of individuals. And then consider how in practice you go about repapering, or perhaps not repapering, but somehow finding a way to deliver this information to the individuals concerned. And then lastly on this slide, outsourcing management. So this is going to the need to re-document your arrangements with service providers processing data on your behalf, which it is a particularly difficult area because the requirements of the GDPR are very prescriptive. They're typically understood quite differently by the customer community and the supplier community. So in theory, there should be quite difficult negotiations between each firm and each of its dozens or hundreds or thousands of service providers. But there is no, I mean, it's not possible to devote that much energy and resource to that process. So it's a way of addressing these issues in a practical and swift manner needs to be identified. And then lastly, international data transfers. The restrictions on international data transfer are not actually materially changing, although there are some adjustments. But again, because of the fines, there's more potential risk associated with continuing with business as usual. So there's a need to review your current strategy, make sure, at least for the most part, that you are that you're within the scope of the rules, that you have appropriate agreements in place to overcome the restrictions, or that you fit within a derogation within the GDPR, which allows you to transfer personal data without appropriate protections. And again, there's going to be a need to prioritize data which are relatively high risk. Data subject rights, it's not yet clear whether there will be an avalanche of new attempts to exercise data subject rights or whether it'll just be a trickle. But firms need to be geared up to respond swiftly so that they can continue with their processing uninterrupted where these rights are exercised against them. So new processes and procedures need to be put in place to anticipate, to identify identify how the firm will arrive at an appropriate response, and then how the response will be communicated to the data subject and who should be involved in the process. And then finally, local issues. Unfortunately, although it's now February and May is only a couple of months away, in most member states, the associated law that will sit alongside the GDPR is not yet in final form. There are one or two exceptions. For example, Germany has a law already finalised. The UK's law is pretty well advanced. So firms need to be on a country-by-country basis thinking about how rules about HR processing, for example, or processing of sensitive data are going to be different still in each member state, whether the approach of the member state is essentially to preserve the position under the current law or whether they're doing something radically new, which I don't think is the case in most cases anyway, and work out how they can accommodate those differences into their compliance superstructures going forwards. So I hope that's been of some help. What I've attempted to do is to identify the key features of the new regime in terms of differences between the data protection business as usual situation that we have today and the world that we're moving into under the GDPR, and then to map out at a very high level the kind of steps that organizations are needing to take to adjust to the new regime and to sort of inculcate, if that's a word, privacy into their culture more fully than it has been in the past. On this slide, I've just hinted at some of the difficult issues that firms are facing, but I'm not going to go through this slide in detail, particularly as I've been speaking probably for longer than anybody would have wanted me to. At this stage, I'm going to hand over to Nicola and Nathan and to anybody in the audience who wants to raise questions for each other, hopefully, but also for me.
Great. Well, thank you, Richard. That is very helpful. You did very well, I think, to get all of that into half an hour. We have had one or two questions in from the audience, and here is one for you. What is the impact of the 25th of May go live on some of the investment banking functions like record keeping, maybe appears on one of your slides, transaction reporting and confirmations?
I'm not sure how to respond to that question. Well, all of the rules apply to all of those activities to the extent that they involve processing of personal data. but that doesn't mean you have to stop them. To the extent that what you're doing is a legitimate activity, or indeed is an activity that you're required to continue by law, which will often be the case in those areas, you will be entitled to continue. You may have transparency requirements in terms of giving individuals who are affected fuller information about what you're doing with their data. You may conceivably be faced with objections from individuals, and you'll need to be geared up to have an appropriate response. If somebody says, you're processing my personal data for this purpose and I want you to stop, you need to be geared up so that you don't just ignore it. You explain that you have a compelling legitimate reason for continuing the processing and therefore you're not going to stop. Nathan.
Yeah, I guess a couple of points. First of all, obviously, very important to identify where, in fact, you're processing PI as part of these transactions, because a lot of the investment bank activities may well be out of scope for this purpose. Where it's in scope, I think we're likely to have very good justification for the processing in order to document why we're doing it from the possible legal bases. But the bigger challenge is likely to be for financial institutions about making sure we delete the data when it's no longer necessary. So being very clear about why we need that data so you can know when it needs to be removed. I think that would be probably the key thing to consider.
And of course, deletion, it's easy to say, but much harder to do if you think about it in the context of a real institution with all of its systems, and particularly when you're talking about personal data in a context where the focus may not be on personal data, but maybe on corporate data, where the personal data is incidental, to have a system which allows those data to be deleted when you no longer need them, and other data that does need to be kept to be retained, poses very considerable challenges, and perfect systems are not possible.
Great, thank you. And then we had another question in about the data protection officer, and there's a question about whether expand a little bit on your comment around how firms should decide whether or not they are required to have the DPO, or perhaps is it that some people are not sure and then deciding that, well, they will appoint one? What's the do you expand a little bit on that?
Well, if I don't have a copy of the regulation in front of me, but just to tell me if I get this wrong, there are separate rules for public sector, but in the private sector, there are essentially two circumstances where you're obliged to appoint a data protection officer. Sorry, three. The first is where, as a core part of your activities, you carry out large-scale processing of data in any of the sensitive categories. So that's health, criminal record, trade union membership, and so forth. Second is where, as part of your core activities, you carry out large-scale monitoring of the behaviour of individuals. And the third is where you're required by an additional local member state requirement. So, for example, Germany, in its law, requires appointment of data protection officers in a very wide range of circumstances. So, and there's guidance on the circumstances in which those criteria apply, at least the first two. I think the basis on which firms, by and large, have been concluding that they do need to appoint data protection officers is that compliance activities are core activities, at least for a financial services institution, and they, in one way or another, require both monitoring of individuals' behaviour in terms of transaction monitoring, and also processing of data in sensitive categories in the context of AML checks, for example. Now, I think it may be that it is actually debatable for any given institution whether the criteria do apply. But as I say, anecdotally, my impression is that in the financial services sector, I suppose I'm not sure that I mean the entire sector, but I'm talking about banks and insurance companies at least. The view is being taken that data protection officers are necessary. I mean, I would say in my client base outside the financial services sector, many people are bending over backwards to take the view that appointment of a data protection officer is not necessary and on perfectly legitimate grounds. But I think in the context of a bank where there is so much personal data, even in the wholesale context, there is a lot of personal data being processed for quite sensitive purposes from a privacy perspective because of the nature of the regulatory scheme. It's quite bold to reach the conclusion that you don't need a data protection officer. Also, sorry, I'm going on a bit about this subject, but in the context of an organisation which is in a very compliance-conscious sector, appointing a data protection officer doesn't feel like quite as much of a challenge, I suspect, when you've already got money laundering officers and goodness knows what else. And you probably, you may already have a data protection function, as opposed to a concrete manufacturer who would think that this was a bizarre thing to do. So, I mean, Nathan, I don't know if you have anything to add to that, but
yeah, just a couple of points. One, I think is an area where perhaps my impression, at least, is that within Europe there's a higher degree of comfort about the role of a DPO than perhaps coming from the US viewpoint, when DPOs is a less recognised concept. And so there's a slight divergence between the regions in terms of their approach. But the important thing is just to note clearly, one, if somebody has the title DPO, even if you don't believe they're actually covered by mandate required by law, the Working Party 29 provide a clear guidance. If they've got the title, they're going to be deemed to be fulfilling the role with all the rights and obligations which perform. So
and it doesn't seem likely that people are going to challenge that view. Or I can't imagine having that argument with a data protection authority. We call them a data protection officer, but they really aren't. No.
Absolutely. We might well find some of the locations we're not so. The terminology has been adapted for other reasons. Second thing clearly is when you're dealing with a regulator, were you to have a problem, it's thinking about whether you're also justifying why you don't have a DPO at the moment when you're justifying that something went wrong. So considering that might be relevant.
Okay. And we have another question coming in, and this is to do with whether there is any difference in risk between processing of personal data of firms' staff compared with processing of personal data of clients who are natural persons. And I wonder whether this question is going back to what you were talking about in terms of data protection impact assessments, Richard, assessing whether any particular kind of processing is high risk or not. Is there any particular distinction in that case or otherwise between processing data of staff and processing data of clients?
Well, I mean, the starting point, to give a very misleading answer, is that in a way there's no distinction, because the rules, with very limited exceptions, just apply to processing data about individuals, not individuals in particular categories. But in practice, of course, there are very different implications depending on who it is you're talking about in terms of risk. And indeed in terms of what you actually have to do in a given circumstance. So I suppose I would sort of very loosely divide the world of data subjects into three categories, actually. There's, at least in this context, there's staff, and of course there are things like employees, family members, and various independent contractors as well as employees and so forth. And the second, as you'd say, would be individual clients in a retail or a private banking context, for example. And then there are the sort of miscellaneous individuals who are employees of corporate clients or employees of suppliers or other, website visitors, other individuals whose data comes across your desk, as it were. And the third category, the rules in principle apply in full, but that clearly is where the risk is lowest, because by and large, for the most part, you're processing data about them only in their professional and not in their personal capacity. That doesn't take it outside the scope of the regime, but the risk has got to be considerably lower. The other two pools are higher risk, and I guess then it is going to depend on the circumstances. I mean, in terms of reputation and profile and the interest of the supervisory authorities, I suppose information about individual clients is more significant. In terms of sort of making the business work and employee relations, employee-related data is extremely important. So, both of them are potentially in high-risk categories. Processing of both of them can require data protection impact assessments, certainly.
We have another question coming in now. This one strikes me as being a kind of organizational question. It's talking about, I think, the interaction between the data protection officer and individuals with senior manager functions under the SMCR. And I guess with the data protection officer looking across all of the lines of business, presumably the DPO would have interaction with a number of SMFs. Question is, how do you envisage the interaction between these individuals within a firm?
I'm going to hand over to Nathan on that one because I think that requires an internal perspective.
Yeah, it's certainly a challenging question. I think here, from the DPO's perspective, you've got to very early on identify all the different groups you're needing to actually report up to, because you have to report to the highest level of management. Clearly, one of those is your senior management function, but you're also having to do the same for your US or headquarters, wherever that might be. So you've got multiple different groups you may have to feed up to. In relation to the senior management function, either you've got to choose one person who's going to be overall responsible, but that's difficult to achieve. If you don't, you're going to need to ensure that you're feeding up to the relevant forum committee where a number of senior managers are present who have got partial responsibility for privacy. I don't see it easily. It's a horizontal risk, and therefore probably each of the senior managers has to take some responsibility for that risk.
I suppose I'd just say that there are data protection officers on the one hand performing a statutory function, and then then separately there's the question of how you manage data protection risk. As it were, even if you weren't obliged to appoint a data protection officer on the other, and there's obviously some overlap and coincidence between the two, but you need to focus on actually managing risk in practice and having the appropriate people at an appropriately senior level aware of what's going on and being in a position to take steps to make sure that you comply. So that's a bit of a vague statement in response to a relatively specific question. That's the best I can do.
Well, I think we are almost up to our time. So thank you very much for joining us today. Thank you for all the questions submitted online. That's really helpful. Particularly like to thank Richard and Nathan and Nicola for joining us. And also just to mention a couple of other things, we have a further GDPR implementation roundtable with PwC in March. And we're also running our second annual Legal and Compliance Conference in October, and data will definitely be a theme at that conference. So we will keep you posted about that through our events team. So thank you everyone for joining.